kanalen. I dag skal vi ta opp nok et interessant tema, så jeg setter over til studio.
Thank you very much for joining us here. Gracias, Kalut, barrister from Norway, and also our friend with whom we have worked in many cases concerning Polish citizens in both Norway and Poland. Mariusz Reikeros, Norwegian lawyer, famous from the Strandloben case, of course, and from many other cases of the human rights and respect for family life cases, and Rune Fardal from the Family Channel, and a great friend of the families and people persecuted by Barnevernet, as you call it in Family Channel. Yeah. May I ask you, Gracia, for your comment or remarks, or your own personal experience in those cases, in the perspective of the decisions of the European Court of Human Rights and the general standards of the respect for family life?
Yes, of course it is. You have had a really good presentation today, so you have focused on these points which are really important. I mean children's identity, religion, the language, which they lose when they are placed in a Norwegian foster care. It's a really important case, I think. And meetings between parents and the children, I think it's absolutely not good that it's only so few meetings in a year. In other countries which has similar systems like Sweden, it would be much more meetings in those similar cases. So it is possible to organize it on other way. And sometimes I'm wondering if social workers have enough competence to deal with these cases. Maybe they had to have some more education on some fields. The most difficult cases from where I think it's made a lot of mistakes is the cases where the child has a special needs, medical needs, and I know at Barnevernet don't have this expertise, and sometimes it is like too late when they get this expertise. It's first when the child is placed. It's really not proper way to do. So it's a lot of topics we can take, but also how because we are Polish here, I want to say at Norwegian social workers have to understand that Polish citizens have other kind of culture, other kind of family life, and other kind of point of view, and they have to have this perspective when they speak with Polish parents and when they examine them. So it's important to know. And other important thing I have to mention right now is when I'm really embarrassed when I hear that Barnevernet not allowed the parents to speak Polish with the children under meetings. It's really broke of the law. It's really bad, I have to say. So it's maybe I can end with that because it's really serious, this topic.
Thank you very much. In many cases reported to us during the research for the report, we have heard that of this lack of possibility to communicate with one's child in the foster care during those few meetings given by the Barnevernet, given by the system in the national language in the mother tongue. This is something very crucial, for instance, in the Polish families, but not only in Polish families. We experience the same in many families from other cultures and immigrants from other cultures in Norway, and that was also an issue in few of the most important Polish cases. Among them, AS versus Norway, that was already decided, with the mother who was deprived of contacts with her child for many years in Norway. It was a violation as it was declared by the European Court of Human Rights. But even some of the contact letters given to the foster families were not handed over to the child. And in other cases reported by the families, we have approached and asked for their testimonies to the report, and the names are not given in the report, but the testimonies are of course in the files of the research. There was a supervision given of the employees of Barnevernet to each of the meetings, and the supervisors were not fluent in Polish, so they made the parents to speak Norwegian. And of course there was no possibility to rebuild or even to try to rebuild this emotional bond between parents and the child trying to speak Norwegian. And in one of the cases, and it is issue of the religious identity, the mother, having only few minutes left for the contact with her son, tried to pray with him, as she used to pray with him in the family house, in their family. And then they were approached by the officials, and the meeting was closed because this was out of the standard. It was not allowed to do so. Of course, those are things that we are not used in Poland and most of the southern model countries, but in case of the religious identity and language identity, it is also out of line of the northern model. We didn't experience this kind of violations in Swedish or Denmark cases we had, or the cases from the Netherlands, with the exception of this one very important case of Denis Lisov and his daughters, this citizen of the Russian Federation who escaped from Sweden, because in this case also the religious identity rights were violated. And it was the reason for the Polish courts to grant him protection in Poland. Thank you very much.
One only remark. I also want to say something about, because we were speaking a lot about the parents' position, but I want to say there's some needs on the other side, foster care's parents' position. I think they have to have some education about the child they get in their house is like they get a function which is temporary. It's not your child. You don't have to act like it's your
a missionary.
Missionary or because it's really a problem, because these parents, which foster parents who don't have this training, they act and make a loyal problems between the child and them. They are professionals. They should have it's like a job they are doing. There are feelings there also, but I can see that often foster parents, they put the child in a really bad position because they are not speaking positively about the parents. They're only speaking negatively, and suddenly the child has really reserved against their parents and would never see them again.
The need for special education of the foster parents is also mentioned in the report as part of this reorientation of the system towards the reunification of the family.
Yeah, because it's a big job to do on the other side also.
Yes, of course. Thank you. Thank you very much. Marius, you are one of the first people I met here in Norway while starting our research on the Barnevernet and the Sile Garmo case in the very beginning, just a few months after she left Norway to Poland. What is your position? What is your opinion with all your experience in the human rights cases and the family cases?
Well, first of all, I would like to congratulate you with this report and the remarkable job that you've been doing. I'm truly impressed with the work, so all the best to you for that work, and that this work will be a tremendous tribute to the people of Norway as well who are fighting this system. So I'm very proud of you, actually. I was very happy to see that when I got a copy of the written observation from the European Court, because I'm involved in some of these 16 cases pending. We had the possibility to make some comments upon your observation given by the president of the second section, the Icelandic judge, which we did. We made these remarks a couple of weeks ago with regard to this Ensby case, which is quite a famous case here in Norway, which has been covered by the media quite a bit. So I may have some news for you with regard. I don't know if this can relate to your report itself, but I can say this is supposed to be a little bit confidential until now, but you know, this is a case similar to the Loven case where they adopted this child only a few years after the child was taken into public care. And 2 days ago we received a telephone call from the community lawyer who was obviously instructed by the government lawyer to start to uplift the adoption process, to start for the family to meet the child. And they haven't seen that child for many years.
That's a change.
And that's a huge change. Of course, we are extremely curious to see how the government lawyer has responded to the European Court. Of course, obviously, I believe that there are some acknowledgements of some breaches here. But it's obvious that the work that we have been doing for years finally pays off. I took notice, of course, when you made your observations to the European Court. You had the two cases you were referring, of course, to the Strand-Loven case, as well as the KO and VM case. And after that, you referred to the AS versus Norway and the other case as well. So we had, within only a few months, 4 convictions against Norway. And as you have been describing very well in your presentation, we see that there is a pattern here, of course. I think that, for instance, in my opinion, if you see, I think it's not coincidental that after the Loven case, they made the verdict in the KO and VM case. I think that was very done by purpose by the court, because it illustrates, in my opinion, that's the weakest case. That was the strongest case the government had. And even in that case, for those who are interested, you should read the premises in that case. Even in that case, where the applicant, at least the male applicant, had a very violent past, you can see that even with such a bad past, you are supposed to take measures to reunify the family as soon as possible. And when you have that as a measure, you can imagine all the other cases, because involving all the other cases coming up now, there are actually normal families. I think I know at least 14 of the 16 families who are involved in the cases you have been intervened in. And these families are perfectly okay. I mean, it might not be the most resourceful, strongest one, but at least there's nothing wrong with them. So I think the court, by that decision, made a very clear signal, and they follow up with these 2 judgments on December 19th. And now you've given a very, and credit to you for your observations given to the court, which was splendid in my opinion. So I think that, and of course, we see now that, as the Lithuanian judge expressed exclusively in the Loven cases, this is not only about private parties versus the Norwegian state, this is also about interstate actions, claiming that we have cases involving Bulgaria, Poland, Romania, of course, Sweden, Russia. So there are a lot of countries involved as well. Bulgaria, of course. So we see that we have lifted these cases up on a very high level, also on an international level. So I do believe that Norway is going to be forced, and we have the Supreme Court of Norway will now rule on 4 cases from 4th of February this year, in only 2 weeks from now, or less than 2 weeks, where they, I believe they have to just endorse the judgments from the European Court, saying that we have to alter, we have to change the path. But saying so, I do believe, I'm still surprised to see how reluctant Norway is to comply with the judgment, especially in the primary case where I'm involved in, the Strand-Lobben case, because, and of course, I have to admit that I'm very disappointed with the Minister of Children Affairs, Kjell Ingolf Ropstad. I have to admit that, because I believed with his Christian attitude that he was supposed to at least start the process to reunify mother and child, because the child was also convicted in that case. But we still have a long way to go. As you may be aware, the mother tried to give her son a birthday card just after a few weeks after the judgment, and she was met with a restraining order from the police. And we have tried that restraining order all the way up to the Supreme Court, and the Supreme Court dismissed the case. So what we have done now is to present Lobben number 2 to the European Court, saying that there is another violation, and this time there is a violation of Article 46 in conjunction with Article 8, meaning that, and we truly believe that the court is able to, because this is kind of like a fresh application in terms of that you meet the applicants with retaliation in a way. I mean, there was no need to give that woman a restraining order just by her passing her readings through her son. So it proves, like Jan Åge also said here, that we have some, even though we are definitely on the right path. Personally, this has been worldwide news. I mean, I'm going to New Zealand in a few weeks because even they are inspired by the work we've been doing here. So this is getting big, but at the same time we have some tremendous challenges because we have a very arrogant government, in my opinion. And as I can only agree to a lot of things that Jan Åge said here as well, that we need to sort of like educate the people, because most Norwegians are ignorant towards these problems. I mean, they are confident in their own little world, they have their comfortable lives and so on. So, and as long as the majority of the Norwegian people are more or less passive to the violations going on, I mean, the government can be at ease when it comes to like take these things seriously. And that of course disappoints me to see that even after 4 convictions within only a few months, showing that there is a structural problem, and the executive committee of the European Council, which is to supervise or to execute these judgments, have already classified the Lobben judgment as an enhanced procedure, meaning that that's only the most serious cases are to be applied under the enhanced procedures. So it proves that the international society obviously states that we have some severe structural problems going on in this country. But at the same time, we have a government that is obviously not able or willing to even to obey to the fundamental rules of Article 46 of the Convention. Because the Convention rights are really simple, I mean, and it has nothing to do with paying out the compensation given by the court. It's very easy to say that if there has been a violation, the applicants are to be put in a position as the violations had not occurred.
I can also another question to both of you, Gracia and Marius. One of the reported violations by experts, by families that we have interviewed in the research procedure was the attempt to bring back the families that escaped from Norway with use of Schengen information system or criminal procedures here in Norway. Have you experienced any kind of that attempts that are a violation of the general norms and principles of law, and mostly the criminal law, and might be a violation of the Schengen system in order to bring back the families here.
If you can try to specify that question a little bit more.
There were some there were some reported cases where the Norwegian authorities unnoted the Schengen information system with the information that families and children are missing, while in fact they were living in other countries, in Czech Republic, in Poland, in Bulgaria, and the Norwegian authorities had all the knowledge that they are there and that they have moved their place of residence to this another country.
Yeah, of course. I'm familiar with several of these cases. You can even go beyond Schengen and say you go to Dubai and even to all different parts of even Ethiopia and different parts of the world. In my opinion, we are obviously discussing some serious potential violation of, for instance, Article 8 of the Convention once again, because the disrespect of the family life is so immense. So even at that stage, you can talk about potential violations of Article 8, which is the primary article that Norway is violating. We haven't tried. This is like these kind of cases have not been tried for the European Court, as far as I know yet. But it should be interesting to try it, and at least now we're bringing up another topic in the Loven case, in the Loven 2 case, where we are bringing up Article 46 in conjunction with Article 8, bringing up at least some other aspects of the potential violations going on in this country. But I truly believe that we will have some of these cases also before the court.
Thank you. Would you like to comment?
Yes, I'm thinking of about the cases I had, and I was really surprised once when I get a case. It was about children who was placed immediately in the beredskapshjem, and they have been living in Norway before, but they have moved to Poland. And Norway get a message they get the information they are on a visit in Norway, on a holiday, summer holiday, and Barnevernet keep them. And it was for me it was clear that they don't have how to call it, jurisdiction to do it, because children was living in Poland, going to school in Poland. Just visiting, but anyway, this temporary thing took 3-4 weeks to get them home. It was they agree with me. It was no problem. But think about these 4 weeks these children lose in the summer because somebody didn't understand the rules.
Yes, and that's the reason we had this recommendation in Poland for many times: do not travel to Norway with your children, because in the end they will go back home, but you never know when and how long would it take.
And here I can see that Polish government was cooperating really well with Norway. There was really quick communication. But anyway, to move this process to return it, it took weeks.
Thank you very much, Rune. We met for the first time just when I met Marius and Gracia here, and from then on we met for many times, both in Oslo and in Warsaw.
Yeah.
You were there 1 week ago even.
Yeah.
Thank you very much for all your attention given to the families and to the Polish families as well.
Yeah.
What's your opinion? What's your comment on the issue, and maybe on our report as well?
Well, to start with, my person beside me here left off the breach of law, that the Norwegian social workers, they don't seem to understand the law. You had a consul here, Mr. Kowalski, who was filming while he was representing Polish citizens in a city called Hamar. And we all saw how the Norwegian police treated the consul in breach with every.
I would just ask that this video was published by Ordo Iuris, and it has more than 300,000 viewers so far.
But it shows the lack of knowledge with the police, social workers, and the last months have shown that Norwegian court systems are totally unaware of international obligations in the so-called NOW system. So we have seen this lack of knowledge about the law, the lack of knowledge of scientific knowledge in this system. So it's lack of general knowledge on several fields that actually is coming up in these court cases and everything. And now we have 5 judges or 5 court decisions against Norway. 28 is now pending, and the ones that's come already contains the things that is waiting in the other court. So I expect a lot of them will be against Norway in the decision. So I travel around Norway, especially western part of Norway, and talking to all these families. I have interviewed hundreds of families. As Mr. Marius mentioned, people have run to Dubai, and we have gone to Dubai interviewing them, and you just talk about the religions aspect that is not upheld as in the conventions we are obliged to. That was in a case in Dubai, that there was a Scandinavian family, and actually a childcare part of this city, Oslo, was involved in that one. And what I see is a system, because that has a law, the Barnevernet law, is actually not so bad, the law, but it's not followed. The law is not followed. They have, for so many years, gotten away with their own interpretation of that law. And that has been a bad culture. And I think the start with Bonayo case, especially, showed the whole public, the whole Europe, the whole world, actually, that something was seriously wrong about Norwegian childcare system. Because on the paper it looked really good, but the paper and the system the parents and children meet are 2 different things. When I talk to the families, what strikes me is the fear this system is implementing in the children. They are like the Bonayo case. They moved after they got the children back. And why? Because the children was afraid to go to school. They didn't know what they picked up today, or did they come home today. And that fear is spread all over Norway. And I think that has to do with social control. They can call it many things, but it ends up in sort of social control. And as one of the former foreign minister in Sweden say, Norway is the last communist state in Europe. And people laughed, but he got a key point there. The control of media, the control of people through fair and court system. And now that we're seeing the court system collapsing, they don't actually know the law that we are obliged to follow. So that's where this report is coming in. And
to be honest, I have to add that after the Stalinist times in Poland, the interference of the state in the family was not as far-reaching as in Norway our days, especially in the 70s and 80s. The general principle of the subsidiarity was followed in matters of the family law.
I want to say about one thing which I can see from my perspective, like a lawyer working with parents and cases all around the Norway. I can get the case from the north of the Norway, from the side, and what I can see, in a case, for example, about violence or suspect of violence, the same case can be treated differently in different communes. You know, it's no like a solution for the same solution for the case. It's like up to this commune how they will lose this case.
That's something we experience.
I think it's in this kind of cases, which is that serious. I know it is like lines about that, but it's still a lot of like possibility to make choices. That the same cases can be solved differently in different pieces of Norway. It's like unbelievable. I think it can't be like that any longer.
If I can comment on exactly that point, that the way families are treated are so different from one commune to another. I have an example just south of Oslo here in Tønsberg city. This family was treated very bad because they didn't come to family center for the 4-year control of their daughter. But they choose to go to the doctor, which they are perfectly possible to do. That ended up in worry to the childcare. So they moved to over the fjord to Sarpsborg, another city. And while they were treated very bad in Tønsberg by the Barnevernet there, the attitude to the family in Sarpsborg was totally different. They brought them in, and the family brought me with them, and it took me and the father, because the mother went underground with the child. They was afraid, scared. It took us 38 minutes to cancel that worry message, and the whole case was cancelled. But the way we were met in Tønsberg, it was like, we're gonna take you. In Sarpsborg, they were friendly, they were listening. We understood, they were hearing what we said. And it wasn't difficult when they come up with a paper from the doctor say they had the 4-year control, no problem. Case end. So it's like a bingo system. If you're lucky, you meet the right people. If you're not lucky, you meet the wrong, and it can get serious consequences.
That is something that we experience also in Poland, especially in the countering domestic violence system. I'm the secretary of the Governmental Council of Combating Domestic Violence in Poland, and we experience, as the law on domestic violence was copy-pasted mostly from the Scandinavian countries in 2005 and then 2009 amended, we experienced this diversity in implementation of the law in different parts of Poland that doesn't respond to the need for unified execution of the basic rights and the guarantees of the family life, mostly family life in Poland. And of course, this is something interesting maybe for you, that according to the Fundamental Rights Agency research published few years ago, the level of domestic violence in Scandinavian countries, Norway was not among the research countries as I remember, but Sweden, Denmark, the level of domestic violence is one of the highest rates in Europe, while the level of domestic violence in Poland or Croatia is on the lowest rates. In the same time, the level of reporting of domestic violence is highest in Poland and lowest in Scandinavian countries. So if we are implementing the Scandinavian solutions to this problem, we are trying to fight the fire with fire. It is not always the best way to deal with that. And yes, of course, this approach to the domestic violence without the proper guarantees for the family, without the proper balanced guarantees, of course, is a risk of violating the basic rights, especially giving the power of arbitrary decisions to the administrative authorities on different local levels that will automatically lead to diversity of ways the law is implemented. Thank you very much. Yes, of course.
Yeah, I would just mark one more thing. I'm very upset to see how the Norwegian propaganda machinery is trying to undermine these judgments as they're coming. It seems like the social elite of Norway is like trying to make these judgments as something like some sort of procedural errors that are not so to be taken into consideration at all. And I'm also very upset to see how they patronize other countries like Poland, for instance. I mean, last week we saw there was even some judges from the Borgarting High Court, which is actually, and they were protesting and making solidarity marches in Poland. And that really upsets me when you see judges from Borgarting, because Borgarting High Court is involved in 9 of the 10 last judgments of the Norwegian in the European Court. So it's really, it upsets me to see how this double moral or standard moral is like twinning around. People are, in this country, people are very conform, in a way sort of like brainwashed because of the oil, I think, that we made them a bit lazy as well. So I can only agree with you. We have a tremendous job to do if we want to really, I mean, we were not even close to the finish line when you see all the work that we have to do to convince the majority of the people here that we are truly suffering from tremendous violations, and it causes like so. That is also something. So I would like to encourage you we have to inform the Polish people about this propaganda machinery, and we have to inform them about the Borgarting that is involved and even sending judges to Poland to like portray themselves as world champions. So that's very important.
That was exactly why we have added the chapter 6 to the report, Barnevernet in foreign and domestic media discourse. Because on many of those issues mentioned in the media, we do not have proper proof of truth. Those are issues raised by the media, debated, discussed. Some of them may be called propaganda. Some other may be attacks on Barnevernet system, unsound attacks on the Barnevernet system as well. But in fact, all the atmosphere around the media in Norway is changing concerning Barnevernet. In the previous years, we have analyzed the media reports on Barnevernet, and it is more and more, and there is more and more criticism of the system. There is more and more approach from the perspective of the human rights and the basic rights guarantees. So the general atmosphere, the social atmosphere, is better and better to facilitate the reform, to facilitate the change of the system in line to meet the European standards of the basic human rights and to meet the European standards of the family life, respect and protection. This is the chapter 6, and of course there is one issue that was worrying for us: those attacks on critics of Barnevernet system, because this is a violation of the freedom of speech and the freedom of criticism, and that's something that is impossible in Poland, for instance, to start any legal action against critics of administration, especially administration, against private persons, of course, but against administration or the authorities. It is something that is probably a violation as well of the basic freedoms. And as to the judges from Norway manifesting together with the Polish judges and some of the Polish lawyers, I have nothing against it. We have a lot of protests in Warsaw, and the traffic jams are then much worse, of course. But in fact it was something signifying that judges from the country where the government has so much to say about the nominations in the Supreme Court are in fact protesting against the reform of judiciary that implemented only partial element of democratic regulation in the process of selecting judges to Polish courts. So it was rather something strange, but of course it is their right.
But speaking about independent judges, I don't know if you're aware of that, and I think Arnfinn Borsen is a good judge myself. I think he's very qualified, but I'm worried that he's on a 9 years leave of his job as a Supreme Court judge, meaning that he is actually formally still in a high Supreme Court position here in Norway, while he's serving his 9-year term as the Norwegian judge to the European Court, which was the same with Erik Møse as
Yes,
well.
the same situation. Yes.
And that, of course, was something we found out in the aftermath of the chamber case, of the Lubben case, that someone informed me that, were you aware that Møse is actually or formally still employed in the Norwegian Supreme Court? And I said, no, of course not. And we involved it. And I think that may have been one of the reasons why the case was accepted by the. And of course, Møse, he resigned from his office 2 years before his term was to be ended. So just to be informed. I don't know how the polling, but this has to do also with the, when you talk about independent judiciary, and you see that there is obviously something you can be, which should be debated here in Norway as well, with the close links between the Supreme Court and the European Court.
Thank you, Gracia. Thank you, Marius. Thank you, Rune, for the participation in this panel.
There's some questions.
Yes.
Kind of a
Questions? Yes, of course.
It's interesting for me when you said, Mr. Kwasniewski, that you had a hard, or I think Sokolewski said that you had a hard time getting the documents from Buftid. It's interesting. I'm watching the proceedings in the Senate in America. Of course, I'm a friend and supporter of Donald Trump, but still, I recognize that he's making it very hard for the opposition to get documents because they are key. It's interesting that the Norwegian Buftid is making it so hard while criticizing others for not releasing everything, you know? So it shows something about the situation in Norway. I think the last 6 years, under Erna Solberg's government, the number of secret court rulings for surveillance of Norwegian citizens. I'm not talking of jihadists in Norway, but I'm talking of probably men like Marius Reikerås and even myself and others who are being surveyed and followed, listened to by phone, whoever we talk to. So I make it a point, whenever I leave Norway, I buy myself a burner phone and I toss it, you know, because that's when you really can talk freely. So I think we're in a situation of great nervousness in the Norwegian system, which is about to turn. So it encourages me to hear Marius and what's your Graciela, as Norwegian-based lawyers who speak so constructively about these things, because that's where it has to be. It has to be Norway, Norwegians standing up, and I think the firmest criticism should not come from abroad. I resent it when I hear, I understand them, but parents who lose their children in Norway and they're from other countries, they use often very negative terminology about Norway. They speak down Norway, they speak against Ropstad, they say, get rid of him, you know. I mean, this is not wise. Respect your country. I think that's respect our culture and leave the tough criticism to Norwegian voices. That's really important, I think.
As to the access to the public data, we are used to the Public Data Access Act in Poland that gives the authorities 14 days to reply for the request for public data. And public data is everything produced without a special clause. And it is very hard to get to put a special clause on the documents. So in fact, you can get everything, even the protocols of the government, everything you can get in 14 days, and it can be prolonged to 60 days in extreme situations. And we were waiting for months to get reply from Bufdir to our basic requests of statistical data, and they were not handed to us without a special assistance from the Norwegian journalists who supported us and got those documents, and we could then analyze those statistics and put them into our report. So it is also some, yes?
just ask you a question? I'm from Bufdir, and you are saying something against Bufdir in a very concrete case here. And can I ask you, because I can see that
We'll send you our requests, yes, and the replies, everything.
But did you ask for a formal, what is the English word for insynsbegjæring? You know, you should know that.
Yeah, did you request for internal documents?
We have
we send
because we have the same system as in Poland.
Yes,
it
so
takes 14 days, and we have to.
We have specified the data, yes, we requested, very detailed.
Our requests were sent by email with information that we want specific data under the Norwegian law. I don't remember the precise title of this act, but I can check it in the minutes. And of course, we have to wait for a long time. After this journalistic intervention, and I sent one more question, and answer was was in a much shorter time, and of course Norwegian embassy was
yes, of course. What we mentioned before, the
standard.
cooperation with Norwegian embassy in Warsaw,
yes,
was much better. But in fact, what was the reply? We don't have data that is not accessible online. You have to ask Bufdir, and then we asked Bufdir, waiting months,
yes,
without reply.
My point is that if you have asked a formal request for
Yes,
to look into some documents, and if we don't answer in 14 days, you are automatically given access to those documents. So what I'm asking is, did you ask for a formal? Was it a formal request for insynsbegjæring? That's my question.
we will send you the documents. We just sent a detailed list of documents and statistical data we needed, and we received no answer.
But I can see that you have referred to a lot of documents from Bufdir in your report.
The statistical data mostly.
Yes, and,
Yes.
and other documents also you have.
We will be happy to
Yes.
receive any remarks. And this meeting today is aims to receive any remarks from your part that can be added to the report, that can influence the outcome of the report, the conclusions of the report. So if you have any remarks, any opinions to be given, in the following days we will be happy to accept anything you want to contribute to the report.
and we also have to say that it's not the substantial question. That is only some kind of methodological problem, that we have no access to data.
Yes.
Yes, so just one, because I think we misunderstood, because we are not talking against, we are talking about Bufdir. We are talking against injustice, actually.
Yes.
But
I perfectly understand.
okay,
It's not what
thanks a lot. So it was just one
clarify, I
remark.
think, yeah.
Okay, but one question, because I understand that we know the status for now, what the status is, but what will be the way? So my question is just about the Polish citizens, because the Polish criminal law opens the possibility to go against those people who violated our rights. So the Polish citizen can go against foreign citizen as in Polish court, and I have heard and I have read about the cases you against the Barnevernet workers. So do you know about the status, how it is?
There is one proceeding in Poland, in the criminal court, against the Barnevernet officials that violated the basic rights of the family in Norway, the Polish family. This case is open and pending, so we don't know the result, what it will be. The case was accepted by the court, and the jurisdiction was accepted by the court in Poland. So those are the information I can give you for now. And what will be the outcome if the rights of the family were violated, or if the rights of the officials were overused, were somehow also violated? I don't know. we will wait for the final decision of the criminal court, but the jurisdiction was reaffirmed.
I want to add one thing. It's the only case pending, but we had another cases that we tried to by the criminal law to chase people who jeopardized Polish citizens' law here in Norway. But there is one big problem concerning the cooperation with Polish prosecutor and Norway prosecutors. They don't answer the legal help summits. They doesn't answer.
There were no answers for the calls for legal aid done by the Polish prosecutor office.
But what then with the new regulation about extradition of the Norwegian citizens, which was implemented, I think it was in the beginning of November 2019. So you don't need actually go to the court or to the prosecutor. Yeah, the Polish prosecutor can just ask about to get the citizen of Norway to Poland. Or am I wrong?
It's not that simple. Okay. Yes, because to extradite you have to start some proceedings, and in here the prosecutor have to check if he have the basis to start the proceedings, and he have to hear the person which is searched.
But here in Poland or here, because in my understanding it was, so maybe I misunderstand, it's possible, but my understanding it was that it will, the directive give us some automatically possibilities just to demand to get the citizen of, for example, Norway according to the condition from those directives without any process on this side.
Yes, but I think the aim of the agreement is that the proceedings have to be started in country, and then the person who the proceedings are against leave the country and to continue the proceedings.
And I will also add that it is not a crucial issue to persecute Norwegian citizens in Poland. That's not something that we aim to do. Of course, in some cases, it might be needed as always, but it is not the aim of our activity. In fact, we all hope that there will be no need for any kind of persecution for the violation of the family rights. And it was the decision of the Polish Supreme Court from just a few months ago that we have acquired after 2 years of our litigation against the Polish Child Protection Services. That the Supreme Court in Poland, the criminal chamber, decided that the officials of the Child Protection Service in Poland may be sentenced because of their violation of the family rights. And before that, all of the courts, the local court, the circuit court, the appellate court, decided that this criminal liability, this criminal responsibility is not possible. So we are changing the situation on a national level, and we hope to influence somehow the situation of other families abroad. But I wouldn't like to stress this element of the criminal persecution, because it changes the general vision of our report. Yes, Jalaga?
Just would like to underscore that although the international battle, even about Norway's Barnevernet, is relevant and important, and I'm also involved in that. Just in 10 days, I'm speaking to 4,000 delegates in Korea, heads of state, you name it, and it'd be an enormous opportunity. But I intend to stand there as a proud Norwegian who does have critical remarks about our system. But still, it's really important to remember that although it's Ordo Iuris who are doing this tremendous work, and several here are Poland-based, this is really, the massive problem is about ethnic Norwegian citizens. That, because I hear the rhetoric from Buftid and Barnevernet environments, that it's all about foreigners. It's about foreigners. It's about foreigners. It's about foreigners. And you know, it becomes like a racist attitude. But it's really the biggest challenge is about Norwegian ethnic citizens who stand up and who are facing an overpowering system. So I just want to underscore that. And although Mrs. Unenigod of Buftid, it's so great that she came, but I would like to say that it would surprise me if Buftid does not acknowledge yourself that you have not been very accessible to others. Because I find I go to Barnevernet offices with victims all the time, and I find again and again that even parents, their lawyers, are being stretched in every way possible, and they have taken the process here are slowed down. The documents are not made available. It's really a rough system to get to terms with, and this is really something that needs a little bit of a humble attitude.
Thank you very much for this remark, because yes, of course, the foreign families are overrepresented.
Yeah.
But still, 90% of children in the foster care are children of the Norwegian families.
Yes.
So it is mostly the issue of the Norwegian families. Thank you very much for your contribution. Thank you very much for your presence today. We have still some time, so if you want to speak, we are available for you. Thank you very much.